So basically the title of our webinar today is AME and QME, which are medical legal evaluations, and this is from an applicant's perspective. I wanted to thank my co-presenters today. I've got QME, Dr. Christine Lam, who's a chiropractor, and Dr. Laura Lam, who's a dental QME, who's also presenting today, and also Mr. M, who's an injured worker, who's been through a number of these exams, and hopefully I know will provide some great insight to all of you for these QME evaluations. So first of all, the question is, what are AME and QME evaluations? And I know in workers' comp, we use a lot of acronyms. And a lot of times our clients don't know exactly what we're talking about. So I want to give you those definitions here before we get started with all the other information. So AME, and AME stands for Agreed Medical Examination. Now, an agreed medical examination can only occur when the injured worker or the applicant is represented by an attorney, and the applicant's attorney, and the defense comes to an agreement on a doctor. This is one of the few areas where the law is different if you are represented or not represented. If you're not represented, if you're representing yourself, we also call it pro per, that you cannot agree to an agreed medical examiner. The other alternative to agreed medical examiner is called the QME, or Qualified Medical Examiner. A QME occurs now for injuries from 2005 to now. What happens is we are given a list of 3 doctors from the state in the particular specialty that we need the exam for. And it's a slightly different process if you're represented or unrepresented, but either way, from that list of 3 doctors, your QME will be selected. Now, all the time we get the question from our clients when they get the notice in the mail or the call that they've been set up for a QME or AME evaluation: why am I going to this doctor? Why do I have to go to a QME or AME evaluation? Well, the AMEs and QMEs are there to resolve a dispute. They're supposed to be an independent examiner who can resolve a dispute, and usually it's in these areas. The first is whether or not there was a work injury. That's called AOE-COE. So if you hear that acronym that we use, it stands for arising out of employment or in the course of employment. That's one issue. If your case is denied, that's why you're going to an AME or QME. Another is a dispute for body parts that are injured. Perhaps you were involved in an automobile accident on the job, and the insurance company accepted your neck and your elbow as part of the injury. But you're claiming that you also injured your knee and your ankle. In that case, the AME or QME may be used to address those disputed body parts. Also, it could be a dispute of temporary disability. Maybe your treating doctor still has you on temporary disability and the insurance company is disagreeing. So they've issued an objection, and we're going to a QME or an AME to address temporary disability. Next, which is common, is a dispute about permanent disability. So once you've been declared maximum medical, have reached maximum medical improvement by your doctors, then we're often going to see an AME or a QME if there's a dispute in how much disability that you have. Now, in many cases, especially in certain areas, the cases that we have in Fresno, for example, many of the treating doctors don't want to address permanent disability. They want to leave it up to an AME or a QME. So in that case, you could say it's not even a dispute, but it is a dispute because the primary doctor doesn't want to address it. Now, in the past, when I say the past, before 2014, AMEs and QMEs were commonly used to address disputed medical treatment. However, currently, most disputed medical treatment is addressed through the UR, Utilization Review, and IMR, Independent Medical Review process. Now, we did do another webinar on that. If you have questions on that, we'll be happy to email you a copy of that. But there is a certain small percentage of cases where disputed medical treatment is still addressed by an AME or a QME. And that is an area called carve-out cases. If you've never heard of this, then you're probably not in a carve-out. But there are some unions that have come to agreements with employers that rather than using the normal workers' compensation judges and appeals board, they use private arbitrators and have a separate set of rules. And for those, most of them do still use QMEs or AMEs for medical treatment disputes. All right, so now we're going to dive into issues that are important for injured workers. And the first is, do I need to prepare for a QME or AME evaluation or examination? So in some ways you should prepare. Now, how much you prepare, it really depends. If your injury is 3 months old and everything's fresh in your mind, there's really probably not too much for you to prepare for. However, if you have a case that's been going on for 10, 15, even 20 or more years, then it is probably important that you go through and do some preparation for your examination. Some things you need to know all of the body parts that are being claimed on your case. Even if you're not getting treatment for them, perhaps the body parts are denied, right? You've been refused treatment. You can also make a list of these if you tend to forget. But it is very important that you know all the body parts, even body parts that are not going to be examined by this doctor. You may be going to an orthopedist, but you also have a head injury. And so you know that that would be addressed by your neurologist. But you do need to bring up that injury. And this will be something we repeat throughout the day-to-day. You need to bring up all of your injuries in every AME and QME evaluation. You should know what happened in your industrial injury. And for those of you that just had an injury 3 weeks ago, 3 months ago, you're going to tell me, of course I know what happened in the injury. If this was an injury that's gone on for many, many years, you may need to review your deposition testimony or old reports so that you can refresh your memory on exactly what happened in your injury. You should know all the medications you're taking and why you're taking them. This is important. The doctors are going to ask you for this, likely during the examination and on a questionnaire that you do. So be prepared also for a long day, especially if this is a psychological or a psychiatric evaluation. It's going to involve testing. It's going to involve one-on-one interaction with the doctor, also perhaps with nurses and other things. So be prepared for a long day. It looks like Mr. M may have stepped away. Mr. M, and again, I want to thank Mr. M. He's an injured worker that's been through a few of these exams. So when you prepare for an AME or QME exam, is there anything in particular that you do?
Well, it's been a long time. It's been 20 years. So you need to get copies of all your reports from your doctors if you can, who are entitled to those. And I make a timeline of what has happened since I got injured, the treatment I've had, the doctors, and how all that worked out. That way, that doctor can see the body parts, we've got resolved, the treatment, the medications are very important to have. And the bigger picture you have of this, the better he can assess your claim in your case and give the best recommendation for your treatment.
And to ask the doctors, is there anything you can think of that would be a good tip for people to do to prepare for their exams, or anything on this list here that you note as important.
Okay, well, you need to know all your medications because there's a reason why you're taking them and if they relate to your case. I myself make a list of medications I take from the doctors from work comp that prescribe those for a reason for my injury. Then I make a list of maybe my supplements and things like that I'm taking as well, so he knows what those are for. So, a list of your treatments where you've had, chiropractic, physical therapy, psychiatric, all the body parts. Even if he's not judging those parts, if you let them know all the parts that they have that you're claiming they're injured, then there's never a question whether you forgot to add it on or what. It's kind of like having your own insurance. But I really recommend, because my case has gone so long, is getting a copy of your reports from each doctor you saw on the way. So if your attorney doesn't have that or needs a copy of that, you have all that. Don't depend on everything just to work out, because it's been 20 years and I'm just now, the past 5 years, been making leeway and getting treatment and so forth. I had prior representation and a couple bad AMEs and so forth. So, but that's kind of just be honest. Do not exaggerate. When you go into an office, they may have cameras on you. So if you have a back injury and it hurts, you're probably going to move around a lot. You'll probably have to get up and down and walk. But be honest, because if a doctor thinks you're not telling the truth, he will take the high road for the insurance company.
And Dr. Christine and Dr. Laura, are there any pointers that you would have that you think that injured workers should prepare more for in advance of an exam?
I think Mr. M did touch base on a very good point. I think it's important that when the patients come in, that they are well prepared, that they have a list of, the injuries that they have, so that they can convey it to me. And also, in addition to that, that they have a list of treatment doctors that they have seen, and the type of treatments they have had, through these particular doctors. So that makes my examination a lot more easier.
Hey, Dr. Laura Lam, anything you wanted to add?
Pretty much just the same thing, that I agree that you should bring a list, especially if you have a claim that involves so many body parts and you want to address everything. It helps whoever's examining you, because we're asking you one question, we're focused on one thing, then you want to point at one other thing, and it kind of can be distracting, and it's really for the benefit of all parties.
And one thing I did want to point out that I think both doctors have indicated is it's very important you be at your exam on time. You should anticipate traffic, parking, and so forth. Remember, the doctors have already set aside a chunk of time for your exam, and depending on their specialty, it may be a longer time than others. And it's important that you be on time for two reasons. One, you want to get all the time you can from the doctors, and so they can concentrate on your case. And two, you want to show the doctors that you care about your case, you care about your injuries, and this examination is important to you. And if you show up 15, 20, 30 minutes late for an exam, the doctors are not getting the impression that this exam or your workers' compensation injuries are important to you. All right, so the next thing, a question that we get a lot is, should I bring my medical records or any other documentation to the exam? So the first explanation we have here is, as far as records go, it's no. you're not supposed to bring any medical records to the exam with you. All the records need to be sent jointly to the doctor by the parties, at least, and they need to be served on the other party at least 20 days in advance. So if you just got an X-ray last night that you really want the doctor to see, that's fine. Get it to the attorney, or if you don't have an attorney, make sure you get it to the adjuster. If you happen to get an agreement the day before to bring in medical records, and as long as it's agreed, then you can do that. But in most cases, the doctor will get the records, but after the exam. So don't bring anything to the doctor unless you have permission. And have either of you, Dr. Christine Lam or Dr. Laura Lam, had occasions where injured workers do try to bring records to the exam?
Multiple times. And I tell them, what happens is they're frustrated. They want this to be addressed right away. And we say, you know what, and I have to remind you over and over again, this is a medical legal examination. Because of that, I cannot see, even though it's right in front of my face, I need all parties to agree to that. And I will not look at it because I will have to ask for permission.
And it's important. It's an ethical issue for the doctors too, from the QME perspective, that they're not supposed to be taking anything at an exam. So I know there's times where you really want the doctor to see things. Maybe you've got it to our office, but we don't have the agreement yet from the other side because we just got it a few days before. Don't worry. Eventually, the doctor will see it, but we don't need to taint the doctor to the point where the doctor can be removed as your QME if they do take those reports for you at the exam. Now, you may be thinking, earlier we talked about notes and taking notes to the exam. So that's definitely something you can get. Mr. M gave us great examples of things to bring notes on: your medications, all the different doctors you've seen. If you've had multiple surgeries, you're welcome to bring that on notes. Now, some people have a very good memory. They could go in there and recite everything without the notes, right? Other people, especially if you have a case that's gone on for 5, 10, 20 years, you may need to bring those notes with you. So you're welcome to bring the notes, but remember, those notes are for your reference. When the doctor starts asking you questions about how were you injured, how many surgeries have you had, you don't just hand the doctor a notebook and say, oh, doctor, my attorney said I should write it down. I wrote it all down for you. Here it is. So you can reference those notes when you give your answers to your doctor. Now, Dr. Laura and Dr. Christine, do either of you, if you have an injured worker that's looking at their notes, do you think of anything, I guess think of anything less or less credible about them because they're using notes?
No, absolutely not. I appreciate it because they're trying to make an effort to, give us an idea of what's going on with their case, with their complaints. And absolutely, I have no objections to that. I encourage it.
Yeah, I encourage it as well. I don't have any objection to it. I find it to be if they do that, it's if they're organized, it makes my job a lot easier. And in order to, if I'm writing the report or evaluating the case and I have issues or questions, it's a lot clearer for me. And, when I'm reviewing their case.
All right, so here's a question that just came up in my head. So for Dr. Christine and Dr. Laura, have you ever had anybody come in and bring their spouse, and it's the spouse that seems to want to answer all the questions?
Yes, I've had it, and I know they're frustrated. I actually asked them to sit in the waiting room just because when I'm examining the patient, the applicant, then I'm trying to get their point of view. Their spouse cannot answer for me what they're feeling. Oftentimes they'll say, well, I often forget a lot of things. My spouse remembers, but then that's why I say bring a list of notes. And just to answer to the best of your knowledge. I don't want to have, it's difficult to try to get a response from someone who isn't the applicant.
Okay. And yeah, and my recommendation to my clients is always, again, it depends, but in 99% of the cases, it should be the injured worker who's answering most of the questions. Of course, we do have those cases where somebody has a guardian ad litem because perhaps they have brain damage or something else because of an injury. And of course, in those situations, if ever there's a guardian appointed, the guardian should always be accompanied at the exam and maybe the only one that can really answer the questions. But in most cases, it's very important that you, the injured worker, give the doctor the answers because you're the best one to give it. And it's also a credibility issue. If all of a sudden you're asked a question about what the pain level is in your neck, and you look to your husband or wife, that could be an issue. Now, if it's a question of how long you've been taking a particular medication and you don't have a great memory of that, and your spouse, memory is like it's still trapped, then maybe that's something to ask them. But in most cases, I think it's better that it's just the injured worker that's answering the questions. Okay, so another question that we get a lot about these examinations is my case is denied and I really need treatment. Will this doctor finally be providing treatment for me? And that this doctor being the AME or the QME. All right, so the answer in general is no. This doctor is a medical legal doctor. If they're neutral and they're providing opinions on the disputed issues, and those being those issues that I had listed earlier about denied case, about body parts, about temporary disability, permanent disability, and the rare cases, medical treatment, but they in general won't be providing you any treatment. However, there has been a rare case where we have seen an AME doctor attempt to give treatment. And I believe, Mr. M, you had an experience like this. Is that correct?
Yes, unfortunately, in the very first 2 years of my treatment, I had injured my back. I had fractures of the spine. And I was sent to an AME, we'll just say a Dr. W. And I went there not once, but a few times. And he seemed very nice. He had cameras in his office and was filming me, which was fine. I had nothing to hide. I went in there and I told the truth, explained what happened and so forth. And he said that my fractures weren't the problem, but I had something called piriformis syndrome. That sounded very serious to me because I never heard of it. But he said, don't worry, I can take care of that. So I first thought, wow, must be my lucky day. So I, after the long examination and questions and so forth, he said, I can do that for you. And I said, well, I need to talk to my primary doctor and also my physical therapist who've been treating me with kinesiology and taping and so forth. And immediately both said, no, that's not your problem. You don't have that. That is a muscle that goes down your back into your leg. It's a stabilizing muscle. And if you cut that muscle, as you get older, you'll be very unstable. So that is not what you need to have done. So then I had to go back to him again, and I thanked him for his expertise because I didn't want to offend him. And so he became more aggressive with me. Well, at that time, the reaction was kind of negative, so I did something that you should not do, as I wired myself with a wire. And I told him I respect his opinion, but I would not be having this done. I would seek other treatment options, as I had opinions from other doctors that did not say I had that. And so then the words came out, look, I am the AIM here and I control your case, whether you know this or not. I can make you or I can break you. I'm doing research and I need 200 cases to publish my findings. This will not hurt you. If you don't have it done, I will make your life miserable. And I had it on tape. So I said again, well, let me think about it again, because I didn't want to offend him, because he seemed to have a great deal of power of my medical necessities. Well, then I blew the whistle. Then he was calling my house, trying to schedule the surgeries to be done at a Long Beach Memorial Hospital, relentlessly. So I talked to my attorney about it. It was not my attorney now. It was one many, many moons ago. And he said, well, you can just have it done. It's not going to hurt you. And I said, I'm not going to have it done. I don't need to have it done. I'm not going to be a guinea pig. So I ended up having to dismiss the attorney because he wouldn't make the wrong right. So I've never had the surgery. I've had fusions done, and it's come out very well. Unfortunately, it was 10 years after I got injured. So when someone tries to pressure you or do the surgery, don't offend them, but just thank them for their advice, and then take it to your doctor, and then take it to your attorney.
And then eventually that doctor was removed as the AME from your case, correct?
Yes, but the problem was his reports remained on my case, even though he was removed, which he was by a court order, because you cannot be an AME and treat the patient. So they removed him, but they kept sending the reports to other newly scheduled AMEs to influence them, and because they were part of my history. So finally, I believe it was you, Scott, got an order to have them expunged from my case so I could get a fair AME hearing.
And that is, and I think that even after they were ruled to be expunged, they were sent by the defense to another doctor, which is why that doctor was also removed. But that goes back to why we can't bring records to a particular AME or QME unless they're agreed on, because for reasons like this. This was a whole ball that unfortunately rolled and let other, got rid of other doctors as well. And that brings me on to the fact that there are a few, very few cases where maybe you were sent to an AME who is very specialized in a particular area, and maybe one of a few people that can do a particular treatment. One example I can give you is a doctor up in San Francisco area who removed, when people have lost multiple fingers, is able to remove their toes and place them on the fingers. And it's very specialized and very few people do that. So in a case like this, where we may use that doctor as an AME, he agreed that this was a particular procedure that should be done in a case, then we can, on some rare occasions, agree to use that doctor as a treater. But if that doctor is agreed to be used as a treater, they're generally not going to be an AME or QME anymore. So and these medical legal doctors are supposed to be neutral and not providing you with treatment. So, you know, as Lane pointed out, this could be a basis for the doctor to be removed as an AME or a QME in this case. And have either of the Dr. Christine Lam or Laura Lam, have you ever had requests by injured workers that you give them treatment while they're there in your office? When you're
yes, I have.
Yes, I
Multiple
have.
times. I have, but the thing is, one is that they need to understand, and that's where I think that they need to come prepared for this examination, understanding that this is a medical legal examination, that we're neutral evaluators and not treaters. But yes, I've had multiple times where they've asked if, one, are they receiving treatment, or at the end, can they receive treatment even after the case is closed? And I said there are a lot of legalities related to that too.
From my perspective, after the case, if you've settled your case via compromise and release and you do want to go to an AME or QME for treatment, I don't see any problems with that at that point. When I say CNR, I mean the case is completely closed. It's not open for medical treatment.
Yeah. But I have seen that multiple times.
You said you've seen that as well?
Yes.
Yes.
Christine?
Multiple times as well.
Okay. So just as a caution, don't ask your AME or QME to treat you. They're not allowed to, and they don't really want to be put in that situation. Okay. So another question we get from our clients is, when can I cancel a QME exam or get a new doctor? Maybe they've heard bad things about the doctor, or they've got some, reason for that. So an initial evaluation with a QME doctor must take place at the location that comes on the panel list. Now, a panel list is a list, we get a list of 3 doctors from the medical unit, and whether you're represented, your attorney gets it. If you're not represented, you get this directly. If the doctor is no longer practicing at that location, then it's supposed to be a different, you're supposed to get a different panel. Another reason is a QME must schedule within 60 days of the first call to the doctor to set an appointment. If the doctor is available within 90 days, the person with the right to schedule can waive the replacement. So what does this mean? This means if we are at the applicant's attorney have the right to schedule the appointment, which is the first 10 days from when we've decided which doctor to use off the list. When you're represented, it's through a striking process. If you represent yourself, it's from when you get the panel. You've got 10 days to schedule an appointment. Now, if the doctor that you're going to schedule with is not available within 60 days, and you don't like that doctor, and it's your right to schedule, then you can go ahead and have that doctor replaced. Okay, if it's a represented case where you have an attorney, the whole panel is going to be replaced because the other 2 doctors have already been struck, one by your attorney's office and one by the other attorney's office. If you're unrepresented, it'll just be that one doctor who's replaced on the panel. Now, if the doctor is able to schedule within 90 days but not 60 days, then you would have that option to get the doctor replaced or not. If it's over 90 days, the doctor's supposed to be replaced no matter what. Now, after that 10-day period, the right to schedule the appointment goes to the defense. And then the defense is the one that gets to make that decision between the 60 and 90 days. Now, and if it's not, so that's another reason why you can get another list or another panel. Next, an initial evaluation report must be completed within 30 days of the examination, or either party may request a replacement panel. So does that mean that on day 31, you didn't get the report in the mail that you can get a replacement panel? No. The doctor has to have it, a proof of service that it was placed in the mailbox or postmarked by the day that the report was due. And that's only for an initial evaluation. There's time limits for other reports as well as depositions of the doctor. If the doctor can't schedule within those timelines, it's not an automatic replacement panel. It's something that you would need to go to court and have a judge issue. Now, I would also tell you this. Currently, and this is just the immediate time right now, because of the COVID-19 situation, they've extended some of these timeframes, and they're much more loose with the timeframes than the doctors, especially when the delays are because of the current virus situation that we have. How long do I have to wait for a QME examination before I can leave? And by this, I'm saying, how long do you have to wait in the waiting room? So if your exam is at 2 o'clock and you have to wait more than 1 hour, no matter what time of day it is, if it's more than 1 hour, then California Code of Regulations, Section 41F says, an injured worker who is not seen by the evaluator within 1 hour may terminate the exam and request a replacement evaluator from the administrative director. Now, the key word in there is may. Does that mean if it's 1 hour and 5 minutes, the exam's over? No. After 1 hour, it's your option, the injured worker. Do I stay or do I go? Okay. Now, before leaving an appointment, if you need to wait more than an hour, you should discuss it with attorney if this is a doctor worth waiting for. Maybe this is a good quality doctor that you're seeing, a doctor that has a good reputation, maybe a reputation that's favorable for injured workers. In those cases, we may tell you that we recommend that you wait because we may get a new panel that may be a much less favorable or much less experienced doctor. Now, if you do decide to leave, it's advisable, if you can, to take a photo of a clock or some way to record the time before you leave if you're able to show that you left at 2:05, 2:30, 3 o'clock, however long you waited, in case it ever becomes a dispute on how long you had to wait. If you do leave, you should call your attorney's office if you have an attorney and let them know what happened and that you left. If you're not represented after you leave, you should call the adjuster and let them know that you've left, okay? Just to record the time, to record the fact that you notified them. If the adjuster tells you, turn around and get back in there, you need to do this exam, I've told you the law. You have an hour after the exam time, and then if you haven't been seen, then you can leave. Dr. Laura or Dr. Christine, have either of you had an issue where an applicant had to wait and left? And
No, I've never had that happen. I've always made it a point to set aside the, a good amount of time so that I can evaluate them properly. And that's why it's important for them to show up on time. But I have never, in my personal experience, had to have a claimant wait longer than an hour.
Yeah, I've never had one where, they had to wait as well. We're very good about, making the appointment to make sure that we can see out the applicants on time. However, I did have one situation where the applicant did show up and there was no interpreter. The applicant didn't speak English. The interpreter was not scheduled, and we waited and past the hour, and so the applicant was able to leave because they weren't able to get an interpreter, a certified interpreter, to us on time.
Actually, you know what? I take that back. I've had a few instances again, and that was related to an applicant waiting because of interpreter issues.
yeah, and if it's an interpreter issue, this doesn't really apply. Even we know that becomes an issue sometimes. If you do need an interpreter, and maybe it'd be best to check with our office to make sure one's been set up beforehand, so we can double check with the defense who's responsible for setting it up. And if you're an injured worker who needs an interpreter, it's good to remind the adjuster as well, because that can become a very complicated situation. But in regards to an interpreter, it's not a reason that I know that the QME would be replaced. Okay, so I know, and actually for this, it's important to note that this really, before we had it, I talked to Mr. M, and he asked me if it's a law that changed. And now that I think about it, if your injury is before 1105, you fall under what we call the old system for AMEs and QMEs, then this wouldn't really apply to you. This applies when we get a panel of 3 doctors and it's a one QME system. Under the pre-2004 cases, it was a dueling QME system and the rules were a little bit different.
Okay, I have one question. It's a legal question. And if you are in pro per representing yourself and the insurance company wants to make a motion to compel you to attend an AME appointment, can they do so?
That's a very interesting question. So, and some of you may have seen this in your cases where you get an order compelling you to attend a deposition or to attend a medical evaluation. Now, there are specific statutes that allow the judges to compel you to attend a QME evaluation, a qualified medical evaluation, or a deposition, or they can suspend your benefits. However, I do not believe there's statutory authority for a judge to compel an agreed medical evaluation. That being said, while there's not specific code for that, the judges have broad discretion in their orders and ordering evaluations. So especially if it's a reevaluation with an agreed medical examination, or there's a documentation that their agreement has been made, then, and there's been a missed exam or multiple missed appointments, then it is something that a judge may order. The question is just, if you disobey the order, what would be the remedy? It's not an automatic suspension like a QME or, in my mind, not automatic like a QME or deposition would be.
Okay.
All right, so here's another question we get a lot. My exam's in 2 weeks or 3 weeks or 1 week. I received a questionnaire from the doctor. What do I do now? Well, the first thing you need to do is fill out the packet. You need to fill out the questionnaire, and not your spouse or your child or your neighbor or your attorney. It's for you to fill out. The questions are for you. You're the best person to answer those questions, and it's going to give the doctor the most information that they need. Now, we can answer, when I say we can answer questions for you, we can answer your questions. When you call up and say, I don't understand what they say when they ask if I have any pre-existing medical conditions, we can explain to you what a pre-existing medical condition is. When the questionnaire asks, if you're carrying a gallon of milk on a pain level of 1 to 10, what's the pain in your elbow? You can't call us and say, what number do I put for that? That's a question for you to answer, not for us to answer. It's important in this questionnaire that you cover all of your injuries or body parts that you're claiming, even if the doctor is only covering one specialty. Even if you're going to the psychologist, if when you were injured because you work at a school, at a high school, and you coach baseball, and you happen to be walking by when one of the kids picked up a bat, swung it, didn't see you, and struck you and broke your jaw and your teeth, and you're going to go see the psychologist right now, you need to list for them. If you've injured your neck, your teeth, your tongue, you need to put all the body parts down. It's important for every QME evaluation. Even if you're going to the ENT because you have vertigo, you need to list your neck injury, your teeth injury, your jaw injury. You need to make sure everything is listed, not just the specialty that you're seeing. And the reason is because a couple things. One, the defense is going to use this against you. They're going to use it to say, you weren't complaining of these body parts or these problems when you saw this doctor. Or this may be the first QME that you saw. And so we're going to ask the QME, what other specialties should you be evaluated in? Well, if the QME looks at the questionnaire and there's no other body parts on there, they may not have anything to refer you to. So it's very important you cover all the body parts in the questionnaire. And I'm going to say this over and over, and the doctors, I'm sure, are going to agree with me, that it's best you're honest with all the questions on the questionnaire. Okay. We have clients call and say, and ask if I have any prior injuries. Well, I have an old back injury from when I was playing football in high school, but my back's not even injured here. I have a carpal tunnel case. Put down your back injury. Okay, put down everything you can remember in the questionnaire. The doctors are looking to see you're honest. And if you're dishonest about something totally unrelated, they're going to question your credibility on all of your answers. I personally recommend that you do these questionnaires well in advance, not the night before or the morning of. As Mr. M told you earlier, that he sometimes goes through some of his records or his list of things that have happened over the many years. Now, most of you don't have a case that's gone on for 20 years, but you're going to fill it out and then think the next day, oh, I forgot something, or you want to look something up, or you do want to ask your attorney for a copy of a record, or what was the name of that back surgery you had. Those are all, great things to fill in, and those are things you can ask us. You may not remember that it was a lumbar fusion at L23 and L34. You just know you had surgery and you want to be more specific. That's a great question to call our office and ask. Now, some offices will have you prepare that questionnaire and answer it in their office. This may take some time, so be prepared. Again, when we say that you could be there for a length of time, make sure that you plan on, especially if you haven't filled out a questionnaire, there's a good chance that this questionnaire will be something that you need to do in the office. Now, Mr. M, you've been to a number of different AMEs and QMEs. Do you know approximately what portion had you do the questionnaires in advance?
I'm going to say probably at least 2/3 or more for the fact that it saves the office a great deal of time. They're usually quite lengthy and require you to really think them through to give your best honest answers. So at least 2/3 that have done so. And I've appreciated doing that because then I could give my top-notch, best, honest answer, because it's your day. You only have this one day. It's kind of like it's your birthday, it's your special day to tell all what happened to you and the reasons why. And that doctor can look at that stuff, be well prepared, and that's why I like doing them in advance.
Dr. Christine Lam, do you send out the questionnaire in advance?
No, I don't. I actually have them do it there, and then I also review it with them as well.
Okay, so you both have them do it in your office, and then afterwards you review the questionnaire with them.
Yes.
Okay. Dr. Laura Lam, do you also have them do it in your office? I think you're muted. We lost you.
Sorry about that. I said, yes, I do. And that gives them an opportunity to go over any questions they may have with me. Sometimes some questions may be too clinical for them and they're not understanding what we're asking. And from there, we can help them.
So if, for both Dr. Christine and Dr. Laura, do you expect them to take their time when they do this questionnaire in your office, or do you have a particular time? Do you tell them only have 20 minutes to do it, or if they need longer, do you give them extra time to do that?
I give them as long as they want. I don't want them to overly focus on this questionnaire. It's just get a general idea on their health complaints. And so my advice to any applicants is that, I know you're scared coming in and not sure about what to expect, but just be as honest as you can. The questionnaire is just one portion of the examination. And we rely on clinical findings, our verbal interactions with you guys as well. And yeah.
And Dr. Christine, do you have any advice for people when they fill out their questionnaires on things to either focus on or?
Well, of course, I would want them to, think it through. I mean, let's say you have complaints of hand pain, and then you're telling me you're able to do certain things physically that doesn't match with what you're complaining. So most importantly, just think it through when you're writing, you filling out your forms, and not over exaggerate, just to be honest. I think that's most important. Um, when we're asking for pain level, if everything's a 10 and you're able to do certain things, let's say you're in the office and you're able to walk and you're able to stand and do everything, but everything is a 10 and you're saying that you can't do anything, then it just makes me question, the applicant a little bit more. But it's important just to be honest.
And I can also point out an example of why it's important to be honest on a questionnaire, and follow up on what Dr. Christine Lam just said about putting a 10 down for everything. That I took a doctor's deposition recently, and I had a client who I think is very credible, and the doctors at all, no one hinted that this wasn't a credible applicant until we got one QME report in, which said that the applicant didn't appear credible. So I went in to take the doctor's deposition, and started out by asking the doctor, pointing out that the doctor in the report said that the applicant didn't appear to be credible in complaints and possible other areas like historian. And so I asked why the doctor felt that, and the doctor had his chart right there and got out the questionnaire that had been done. This particular doctor had a list on the questionnaire that said, listed the body parts, back pain, 1 to 10, 1 to 10, 1 to 10. In this case, it was a case where the applicant had a shoulder and wrist injury. And the applicant had gone down for every body part in the whole body and just circled 10, not even individual circles over the 10. They took it and circled the entire line of 10. And then, as far as the body, where you're supposed to, on this particular, it had a picture of the body, and you filled in and shaded in the parts that were injured. And the person had shaded in the entire body from head to toe. And from the answers were also very cursory in some points, but in this case, I think it was just an applicant who wasn't taking the evaluation very seriously, obviously didn't take the questionnaire very seriously, but unfortunately had a very negative impression on the doctor. So I think this questionnaire is very important, whether you do it in the office or you do it at home, that and whether it's a lengthy questionnaire or not so lengthy. It may be, and I haven't seen either Dr. Laura Lam or Dr. Christine Lam's questionnaires, but I would think a questionnaire in the dental field may be a bit more focused than a psychiatric questionnaire or an orthopedic questionnaire. So, but whatever it is, take each one of those questions seriously. The doctor is, so you should also. All right, so the next question that we get a lot is, what happens before I see the doctor? So we went over the questionnaire, and this is like when you get to the waiting room. While I'm waiting, well, what is it going to be? Questionnaire was not sent out in advance. If you're going for a psychiatric evaluation, you're going to have likely written testing that's done. This testing, sometimes called the MMPI-2, there may be 3 or 4 or 5 different psychiatric tests they give you. Again, take it seriously. Even though I think in the MMPI-2, it may ask you, the first question is, do you read Popular Mechanics magazine? Okay. Well, you may think the doctor is a joke by this question. It's a set questionnaire that's used throughout the United States. It's the doctors take it seriously, you should too. You may meet with a nurse before you see the doctor. You may or you may not. The nurse may take your weight, may take your blood pressure, may take measurements. All depends on the type of doctor. If you're seeing an internal QME, 90% chance they're going to take all your vital signs. If you're in other areas, it's going to depend. Some AMEs ask you your weight. Most of them are going to put you on a scale. So you may go through that. Now, Mr. M, from your experience, is each doctor different in what happens in their waiting room or the initial time before you actually get to see the doctor?
I would say yes, because each office staff is different and most are pleasant. The historians are different, which takes all your history and so forth, which is also very important. Some doctors are happy to see you. Some are, as some probably seen 50 patients and can't wait to get out of there. But it's really good to be upbeat and be willing to answer their questions and to elaborate if you feel you should and that they're receptive to that. So each one is very, very different.
I would also note that the doctor may be observing you in more than one way. They may not just observe what you tell them in the exam room, but as Mr. M pointed out earlier, the doctor that he had the issue with the surgery the doctor wanted to do, also had cameras. And I believe those cameras were in the waiting room as well, right, Mr. M?
Yes, they were.
So he would be viewing you in the waiting room even before you come into the exam. So he wants to see your demeanor. If you're complaining that you can't sit down for more than 10 minutes, is that true? And again, honesty is the most important thing. And that's why. If you write down on the questionnaire, you can't sit more than 5 minutes, right? What's the doctor going to see? He's going to see that you just waited in his waiting room for 25 minutes, on your phone, playing whatever game that you're playing on the phone, no discomfort at all. If you can sit for 30 minutes, don't put 5 on your questionnaire. Be honest. And that's really what these doctors are looking for. And many of them may not use cameras, but they may even use their receptionist that's out front, right? They may, be asking, what were you doing? Did you look like, you're in all this pain that you're in? So it's just be aware to know. And if you're honest with the doctor, you don't need to worry about these things, but it's good to be aware that they may be observing you in different places and not just in the examination room.
Yes, he did make note, as I recall now, that I was unable to sit very long or shift my weight back and forth or stood up frequently. And I didn't really know the cameras at first until I had walked by one and going in. So yeah, they do watch you, and it's probably a good thing to do, if the doctor's on the up and up,
All right, so here's some tips that we have put together for the exam also. So number 1 is don't bring your kids. I've heard this from many doctors, both Dr. Laura Lam and Dr. Christine Lam have pointed this out as well. But you could be at the exam, especially if this is a psychological exam, you could be there for 6 hours. For other exams, you should plan on being there for at least 4 hours. So, again, it goes to taking the exam seriously. And a part of that is making sure that you have people or somebody to watch your kids. That's what the doctors are looking at. Don't be hostile with the doctor. If you're nice and cordial with the doctor and the doctor has something that can go either way, maybe it's something that's a 50-50 chance, you're more apt to get it when you make a good impression on the doctor. This doctor is not somebody to be hostile with. This doctor, you're going to be in much better shape if you walk out of there with this thinking this doctor more of your friend than your foe. Be truthful with the doctor. Again, the doctor is going to be comparing what you tell them with your questionnaire, with the records they have. In many cases, they already know the answers. They may have already read your deposition where you testified that you had 3 car accidents in the past. And they ask you, oh, so have you ever had any car accidents? And they're looking at the answer when they're talking to you, where they already reviewed it and they know you have 3 car accidents. You just testified that in your depo 3 months ago. And then you say, doctor, I don't remember ever being involved in a car accident. All of a sudden, this doctor who from step 1 is believing you, now is thinking, oh, all right, let's see. What else are they going to tell me an untruth about? So it's be truthful. It's very important. Expect the exam to go for a long time, up to 4 hours for a non-psych exam and up to all day for a psychiatric exam. Again, they could have multiple testings. And if so if you have a 10 o'clock exam, don't make a hair appointment at noon, okay? Plan on being there for some time. And if you need to know how long it will be because you've arranged for somebody to watch your kids, you can call the doctor's office and ask, do you know approximately how long I should allow for the exam? Because I've arranged for somebody to watch my kids. Believe me, they'll be much happier that you call them in advance and ask how long to plan for than you show up with 3 kids screaming in the waiting room. All right, when you arrive, especially if you've traveled a long way, use the restroom. If you're going to be there for a while, then you finally get to see the doctor, and then you ask to see the restroom, or worse yet, you can't concentrate because you're sitting there thinking you have to go to the restroom. I highly recommend you use the restroom before you go. Another tip is turn off your phone before you go into the exam room. Okay, if you're texting with your friends or with your family, or you're taking a phone call during the exam, that again goes to the doctor thinking how seriously you're taking this, how much you care. Because if you're taking the phone call from your friend, that guess what, I'm down here at the horse track and this horse is looking really good, and you're telling them, oh, can you put a bet for me? The doctor is going to look at you and think, do you even care that I carved out half of my day for you? You're taking a phone call. So turn off your phone before you get into the exam room. As far as tips, first from the doctors, Dr. Christine or Laura, are there any other tips you can give people for the exam?
I do have one. Sometimes after we're done with an examination, the applicant tries to contact me repeatedly. For instance, trying to see what type of treatment I recommend for them or things of that nature. And they need to be reminded that this was a medical legal examination. I'm not a treating physician for them. And for ex parte communication, it's really important that I'm not supposed to communicate with them after the examination, that any questions they have, if they're represented, they should go to their attorney so that we can communicate with them and all parties.
And another thing that the doctors and I had talked about just before this webinar is that often the injured workers come in with either questions or things that they want to address with the doctor. And at least as far as the doctors here, the impression I got, it's best to wait towards the end of the exam to address things that you don't think the doctor covered. First of all, the doctor may have a general order that they go in to cover things. And if you're going to see Dr. Laura Lam as the dentist, and she's asking you about what happened to your, to your mouth and how, how the injury occurred, and you're thinking to yourself, oh, I have to make sure I tell you that I'm diagnosed with GERD now. It's probably not the time to say it. If the doctor doesn't cover it throughout the exam, then those are things you may want to jot down to talk to them about at the end of the exam, and not necessarily at the beginning or just when you think of it in the exam. Is there any other tips that Dr. Christine or Laura would have for the exam itself?
I also have one more. I would probably recommend if the patients wear, orthotics or any type of brace, that they bring it in with them when they're coming in for the examinations. And that way I have a better idea as to what type of things they need, devices that they use in order to assist them with their pain.
So speaking of pain, here's actually a question I get from clients all the time, and see if either of the doctors, especially Dr. Christine, I think, but sometimes applicants are taking a lot of pain medications, and that pain medication often masks the pain that they really have, increases their range of motion and things like that. So some clients may call me and say, I normally take up to 6 or 8 Vicodin a day. Is it advisable that I refrain or lower my pain medications so the doctor can truly see my limitations before I go to the exam?
Well, it depends on their pain level. I would recommend that if they can bear it, uh, that it would be better for them to, come into the exam less medicated. That way, I would have a better idea as to what their, issues are, what their pain levels are. Rather, like you just said, I think the medication does, some pain medication does mask the symptoms or, the injuries itself. So it would probably be advisable if they can manage it without pain meds or lower level of pain meds that they'll come in with, just a lower level of pain if they can.
Okay. And is it also important that they disclose exactly how much pain meds they're taking, even if they're taking more medication than they're being prescribed?
Yes, to be honest, I think whatever medication they're taking, even higher level, lower level, just to be honest and let us know so that way we can have a better idea as to what their injuries are.
Okay, and just to point out, this would really only apply to pain medication. I don't think any doctor would probably recommend that you cease taking your psychiatric medication or your hypertension medication, or diabetes medication before an exam. And Mr. M, except for the things that we've covered, is there any other tips that you can have for people before they go to an exam?
I think this was an incredible view on the doctor's parts, you directing this and coming from someone having multiple injuries for 20 years. I think this was invaluable, and I thank everybody for being a part of this as you do. I think that, be on time, the honesty, tell them everything, write a book if you have to. So.
All right, so the next question that comes to is, I finally made it into the examination room. I'm finally here with the doctor. What's going to happen now? So again, it depends. Each experience and each doctor handles it differently. Sometimes when you first get into the examination room, you may see a nurse. The nurse may go over your questionnaire with you. The nurse may at least make you comfortable, give you a seat, tell you where the doctor will sit, where you're going to sit, and so forth. Sometimes the doctor will come right in. You may not see a nurse beforehand. It may actually be the doctor who brings you to the exam room. It could be a doctor and a nurse that sees you at the same time. Especially in cases, there's a group that we often refer to as the Fresno group. They're traveling doctors. They travel one nurse and a doctor. The nurse will usually be in there at first while the nurse is checking somebody in later. Now, the doctor should do a full examination in their specialty of you. This exam is, of course, going to vary by every specialty. The specialty that Dr. Laura Lam gives you in dentistry is going to be far different than the examination that Dr. Christine Lam gives you in chiropractics. Dr. Christine Lam's probably not even going to look in your mouth, where Dr. Laura Lam's going to spend most of her time in your mouth. So it's going to be different depending on what specialty that the doctor's examining you in. Now, it's important for you to note how much time does the doctor really spend with you. In some cases, we get QME lists of doctors who we don't find very credible. And some of these doctors may only spend 5 or 10 minutes with you in the exam room. It's very important for us to know that. It's very important for you to remember that and let us know, especially in a case where the doctor spends very little time with you in the exam room. Dr. Christine Lam, about how much time do you usually spend with a patient on a first exam?
I would say around 2 hours or 2 to 3, maybe sometimes 4, depending on, the body parts that are injured, Also depending on, you know, the cases, like if previous injuries or how many cases they've had or prior injuries and whatnot. But I would say, you know, around at least around 2 hours.
And do you personally do the entire examination yourself, or do you have an assistant or a nurse who may go over their questionnaire or something like that?
I personally do them myself.
And how about you, Dr. Laura Lam? About how long do you spend on a initial evaluation with a QME patient? You're on mute. All right, Dr. Laura, if you're there, you're muted.
Oh, sorry about that.
Okay.
I would say on average about 2 hours. And it depends on whether or not, in instances like if an interpreter is necessary, because that will take some time as well. And yeah, and again, how long the case has been, the amount of injuries, and pretty much their history. Yeah.
Now, if I'm getting my QME exam now and you're looking at my mouth and I say, oh, since we're here, doctor, can I get my teeth cleaned at the same time?
I also remind them again, I'm an evaluating provider. I'm not there as a treating provider. And that's the thing, the take home message for me is to remind all applicants is I'm there as an evaluator to obtain objective information and get a history of your injury complaints. I'm not there as a treating provider.
Okay, so, and my guess is especially as a dental QME, back to the tips page, it's probably suggested that people do brush their teeth before they come to the exam. Is that right?
We appreciate that you do that.
So again, it helps how much you care and make yourself presentable, and that is something that should be important for you to do before you go to a dental QME exam.
I would say it reflects on how you take care of yourself. I mean, that plays a big role in your overall health too.
All right, so the next question that people always ask, and we'll call and ask our office the day after the exam, is what happens now, right? I just had my QME yesterday. Did you get the report yet? So reports will issue 30 days typically after an initial QME evaluation. They're supposed to be sending out the reports like we talked about earlier within 30 days of the exam for a QME. Now, AMEs are not usually subject to this time frame. The report may indicate you've reached MMI. So what is MMI? Maximum medical improvement or permanent and stationary status. If you've reached that, that means the doctor in their specialty doesn't think you're going to get better or worse in the next 12 months. In that case, the report should also have for us your permanent disability rating. Okay. Now the doctor may say you're still temporarily disabled, meaning you still need more treatment before you can reach that MMI point. In that case, we won't have a permanent disability rating for you. You may need, after this exams in additional specialties, like the example I gave earlier of someone going to a psychiatrist or psychologist, and you know, after a jaw and dental issue, that doctor may refer you to other specialties. That's why it's very important that you list in your questionnaire, and when you talk to the doctor, all the different issues that you're having as a result of your injury. Now, you may need to see that QME or AME again, especially if you've not reached MMI status, maximum medical improvement, or permanent and stationary. You more than likely will be seeing that doctor again sometime in the future. Okay. I know that those 30 days for many people seem like a long period of time because they've been waiting for a while for that report. But Lane, Mr. M, have you ever been in that position where you are waiting for a QME report, or it's something that's important for your case?
Well, actually, I'm waiting for an AME psych report that I did back in March 9th of this year. So I'm waiting with bated breath, very patiently.
Right. And we do understand as our clients that this is very important for you in many cases and that you're waiting for it. And a couple things is that, one, sometimes the doctors, we may be waiting for a supplemental report. They're supposed to be done in 60 days. A lot of things are taking longer than normal at this time because of the COVID-19. Now, we kind of walk on eggshells in a way where we don't mind calling the doctor's office and finding the status on the report. But in most cases, if it's not a case we want to object or get rid of the doctor, we don't necessarily want to make the doctor upset where they rush a report and we don't get the quality of report that we're looking for. You know, it may be a case that's many years old and the doctor received 4 boxes of records, and it may take them a little while to go through that. And especially in the case of an AME, it's definitely in most cases more favorable for both sides in a way to have an AME, because we know it's a credible doctor and we both agree that it's a credible doctor, so we're not really wanting to get rid of or upset that doctor.
That's right.
All right, so some questions that we got in before, and I'm going to get to the questions that have all been posted. Feel free to put them on. We're going to get to them in a minute. These are some questions that came in to me before they asked me to talk about. First, is this the insurance company doctor or our doctor? And the answer is neither. This is a neutral doctor. Whether it's an AME or a QME, it's a neutral doctor. The only exception is if you have an injury before 1105, then it may be what we call an applicant QME or a defense QME. But my guess is for most people watching, your injuries are after 1105. Well, I have to see the doctor more than once. Maybe. Like I said, if the doctor says you haven't reached maximum medical improvement, eventually you're going to need to go back to that doctor, likely, so we can get a final report and get your permanent disability rated. Should I cooperate with the QME? Yes, absolutely. This is a person you want to get on your side. It's like the judge when we're in trial. We don't want to piss the judge off, right? We want to make sure that the judge knows that we're cooperative, giving them all the information. Sure, we may have to argue at times. We may have to give our position, and that's our job as attorneys. But especially as an injured worker, when you're in the exam, sometimes the doctors tell me that they get, absurd answers from the applicants or injured workers. For example, I've had doctors tell me that they ask how the injury happened, and the response from the injured worker was, "Have you read my records, doctor?" Okay, the doctor, again, they may know exactly what happened already, and they may read your records before the exam or after the exam, depending on the doctor, but they're testing your credibility. And if you said, this happened one way to the doctors that initially after the evaluation, initially after your injury, and now you're saying something totally different, that may go against your credibility. So it's very important that you cooperate as much as you can, with the QME. All right, so now, and feel free to keep typing in questions as you want. If you want, I've got a number of questions here, so I will go ahead and we'll try to answer them between me and Mr. M and both the doctors. So first question is, what if the QME refuses to request an MRI on a certain body part that my PTP requests? Okay, so there's different ways we can get diagnostic tests done. Sometimes when a QME requests an MRI or an X-ray or other diagnostic testing, it's almost a shortcut for us because we don't have to go through utilization review and independent medical review. In some cases, a QME may not find a diagnostic test, such an MRI is important, but your PTP does. Then we hopefully can get it through the PTP's request. You know, if all else fails and you have health insurance, you can get diagnostic testing through health insurance, and then we can present that to the doctors as well. All right. Next question. Is it normal protocol for a QME doctor to make comments regarding the age of your surgeon and questioning the length of time I was in surgery for the issues I had? The second surgery was due to a first surgery the doctor did not complete correctly and additional injuries the second doctor's MRI showed the first doctor did not treat. The QME never questioned the first doctor's surgery and diagnosis. I also believe there is an ethnic belief, male versus female, and age. I assume it means bias. I do not believe QME should bring up his personal issues. Okay, so from my perspective, sometimes surgeons may make comments about certain doctors. Do I think it's normal protocol? No. Do I think it's something that would get them thrown out? No. As far as bias, if you believe there's a bias, that may be something that we can try to investigate, but it's often hard to prove. But I think, you know, in general, if it was my advice to QME doctors, I would tell them that commenting on particular doctors, and perhaps if they have a bad reputation for surgery, or the doctor thinks that the other doctor is too old for surgery, is probably more of a personal comment. They shouldn't tell to an injured worker. I don't know, do any of the doctors have a comment on that? If you do, let me know. But I think that's something that I would recommend. If I was asked by a doctor if they should comment, I would probably say no, but it's not something, at least as far as the bringing up the age of the doctor, would not get a report thrown out. If a QME orders an MRI from body parts, on that result show that I do have a problem with my spine, and workman's comp still denies the case, can I get treatment based on the result of that evaluation? Okay, so this is going to depend on a few things. Number one is if you are unrepresented and an insurance company is supposed to provide benefits based on a QME report, or they're supposed to file for a court hearing. That's just what a code says. Now, sometimes they want to seek clarification from that doctor. They want to send more records to the doctor. That's all things they can continue to investigate. The other thing is sometimes it's a factual dispute, meaning that perhaps you work, again, I'll use a school as a example, and you slip and fell on a playground. Well, it happened to be, it was unwitnessed and nobody saw it happen. And the defense or the employer is disputing the facts of the case. In that case, it may still be something that is disputed and may have to be decided by a judge. So can you get treatment? Well, there's two types of treatment that we see in work comp. There's some work treatment you can get on what we call a lien basis. That's when your case is still denied. And there are other treatment that you can get when the case is accepted, and that's approved treatment. So you can often get treatment depending on what treatment it is, even if the case is denied, but that treatment may be very limited. You can also go to your own health insurance while the claim is being litigated or decided. If you finished a deposition, do you still need to go for a QME? Or just one of these two? Okay, deposition and a QME are two totally different things. If you are represented by an attorney, the only way for the insurance company or the defendant to ask you questions is to take your deposition. They can no longer call you up on the phone and say, oh, can you tell us if you ever injured your back before? can you tell us if, what happened? The only way they can ask you questions is at a deposition. The QME is a medical evaluation. Those are two totally separate things, and in most cases, you're going to see both. You're going to see at least one deposition and at least one QME evaluation. What if the person can't read or write? Can someone else take down their answers to the questionnaire? And this is a very good question. Yes. If you can't read or write, there's a couple different things. We have actually had somebody who could read and write before the incident, but were blind after their work comp injury. So we needed somebody to accompany them to the doctor's evaluation to answer the questions. So in that case, it really depends. In this case, it was very interesting because we had to get an interpreter and figuring out what type of interpreter it was going to be. I don't know if it was sign language or what we ended up doing, because the QME's staff didn't want to help with the questionnaire. So, but yes, somebody else can do it, especially if a person can't read or write. But it should be the answers of the person. And again, when I say fill out the questionnaire yourself, if your handwriting is horrible, you can have your spouse do it. You should be dictating them the answers. I'm confused. The doctor I'm seeing never asked me any questions, not even at my first appointment. His nurse took all the information. This is very important to let your attorney know if you're represented. This may help discredit the doctor if that's what we're trying to do. The doctor, should be participating in the evaluation. Well, what happens? The doctor sees me for 5 minutes, does not let me talk or listen to my medical complaints. And I think we addressed this earlier. This is, again, something very important that you let your attorney know. So we can use it if necessary to discredit the doctor. What if the doctor tells me he has no medical records from me? So this is something that happens often, and partly because we're often negotiating or trying to gather all the records between the defense and our office to go to your examination. Now, there are occasions where the doctor doesn't give the records before the evaluation, or they may get it a day or two before the evaluation. They haven't viewed them yet. There's also occasions where the doctor's got the records 3 weeks before the evaluation, but it's the practice of that doctor to view the records after your exam. So though it is common, and don't let it alarm you, but it is a good thing to let us know after your evaluation if the doctor says they haven't received the records yet. Okay, here's another question. I have a QME appointment this Friday. Due to COVID-19, I was told by the doctor's office that the appointment would not last long due to reducing the amount of time in the room. This will be my third QME with the same doctor. Will this affect my outcome? Okay, so actually I should have addressed this earlier, in that we are getting this a lot now, which is very actually smart on the doctor's part. A lot of them are doing a good portion of the evaluation over the phone or over Zoom or other teleconferencing, and then just bringing you in for a short evaluation so they can do any range of motion testing or other physical testing they need to do. Now, especially if it's your third QME with the third appointment with the same QME, I wouldn't be worried. And even if it's your first appointment and you did 90% of it over the phone or over video conferencing, I wouldn't be worried about that either. It would be if you went in there and it's a very short appointment and you never got to talk to the doctor. That's something, of course, to worry about under any circumstance. So if both sides agree, can a secondary treater be agreed upon as an AME? So this is very rare. In most cases, if you agree a doctor to be an AME, the doctor is not going to be treating anymore. Next question is, my CAT scan showed the fracture to my face, and the ophthalmologist noticed a detached retina. Will this QME have these records, or should we make sure that they have them? So we do try to make sure the doctor gets all the records that we have. But it is important for you, like Mr. M commented on earlier, that you have a list of the various problems that you're having, so you can also tell the doctor about the issues that you have, especially in the case that the doctor often will not review your records until, or at least in detail, until after the evaluation, especially if you have an old case and the doctor may have received multiple boxes of records. All right, I recently received my report back, and he did state that he doesn't recommend that I return back to my dental hygiene job because of my issues with pain in my hand, even after carpal tunnel surgery, and still issues with my back pain. So why would he also state that I am permanent and stationary? He also said no permanent disability and no further medical treatment is needed at this time. He knows I'm still having pain. Does this make sense? Okay, so I'm going to answer this. It's a number of questions, so I'll answer them one at a time. One, can you be permanent and stationary and still have work restrictions that prevent you from doing your usual and customary occupation, your normal job? Yes, in many cases that happens, that you can't go back to your normal job. Now, is it also common that he says no permanent disability and no further treatment is needed? Well, that doesn't make sense, because if we read the AMA guides, 0% disability is reserved for somebody where the injury has little to no effect on their activities of daily living. So this is a case we would definitely want to look at, and we would look at either we want to discredit this doctor and go with our own primary treating physician if it's a QME, or if we feel that we need to depose the QME because we don't have a good primary treating doctor, or if it's an agreed medical examiner, it's probably a deposition that needs to be done. But if you do have an attorney, this is probably a good issue to address with your attorney on what the plan of action would be. And if you don't have an attorney, this would be one of those cases where I would say it may be a good time to consult with one. So next. All right, so I have a question which I don't think I can really address. It says, I have an AME coming up on the 24th. I've had 3 QMEs, so what would I expect from this one? So one thing that I could say is, if we've gone to a QME and then we finally agreed on an agreed medical examiner, it's probably a good thing. In general, agreed medical examiners are going to be more credible and write a much more detailed report because they're agreed on by both parties and they're known to write quality reports. And if we're basically throwing out QMEs in order to go to an AME, that's usually a good sign. And I'll try to address that later in your particular case. Okay, so this really doesn't have to do with AME QMEs, but I'll just go ahead and address it. Someone's saying that they heard that their case is going to be finalized soon, and it's that they shouldn't allow the defense to know they're on Medicare, even though they're of Medicare age, because it may stop or slow down the settlement. Okay, so like I've talked about for many different things in talking to doctors and also dealing with settlement, is that we need to be honest, we need to be forthright, and we have many people we deal with Medicare set-asides as part of their settlement. It's a normal process. It could make things happen longer. In some instances, it may mean we settle a case with future medical care open now, and we settle out future medical care later. So that's not really going to be an issue. Also, if you are over 65, it's common knowledge that 99% chance you're Medicare eligible. All right, so if anyone has any more questions, feel free to type them in. In the meantime, I'm going to ask if any of the other panelists here have any other parting tips for injured workers who may have a QME coming up, or anything else they would like to mention that I forgot?
Not just a reminder again that we are neutral evaluators. We do not represent either parties, that we're trying to be as objective as possible. Can you hear me?
Yeah.
Okay.
Yeah, and that's a great reminder for everybody. Again, this is a neutral evaluator. They're not the insurance company's evaluator, even though sometimes we may get a conservative doctor on a panel. They're not our evaluator, even though we may get a more applicant-oriented doctor on a panel. They are a neutral doctor. It's best you be, honest with them, and give them the best chance to write you a good report. Any other tips, Mr. M, you can think of?
Most of all, keep the faith. Keep the faith.
And how about Dr. Christine Lam? Do you have any comments or suggestions?
I would probably just say, come in, try not to be nervous. We're a neutral party. We just want to get the facts. Just be honest, and then we'll go from there. And that's
All right, so there's a couple other comments here. So one person said, the PQME told me at the time of the exam they're going to order testing, but they didn't write it in the report. What should I do? So that is a good thing to call our office, let us know, talk to the paralegal or attorney on your case. And or if you're not represented or you have a different attorney, talk to your attorney's office. If you're not represented, it's something that you may want to address with your primary treating doctor. We can do a number of things. We can write the doctor and ask. We can try to take the doctor's deposition, or we can ask your doctor, your primary treating doctor, to request this. Okay, somebody also asked if they can have a copy of the slides. And of course, what I will try to do is I will try to email this slide presentation, a PDF version of it, to everybody that registered for the webinar today. And I think that's it. So for those of you that are tuning in on a weekly basis, I hope to do one again next week. And the next topic that I hope to do on is outlining the various types of benefits and their interactions with each other between temporary disability, permanent disability, state disability, unemployment, Social Security disability, long-term disability, short-term disability. This is often a very confusing area when people are getting multiple benefits and who needs to know what when they're getting those. So that's what I plan to talk about next week. I'll send out to anyone who registered information about it. We'll also try to send it to most of our clients that we have in our contact database. And I will let you all go. And thank you again for attending. Thank you very much to our panelists, Mr. M, Dr. Christine Lam, and Dr. Laura Lam. Your information was invaluable for all of us today.
You're welcome. Good luck.
Thank you.
Best of luck to
Thank you for
everybody.
doing a great job. I think your clients are very lucky. I think we have, I have patients that come in and they're so unprepared. And I think just giving this information would maybe clarify a lot of information for them. I think it's tough for them to come in and not know what's going on. And this would probably give them a brief idea as to what will happen during exam. And I think hopefully it will put them at ease. But I think you did a fabulous job with, informing the public.
I agree. A lot of times, a lot of applicants come in and they haven't been informed by their attorneys. So this is really good of you to inform your clients too of what to expect.
All right. Well, thank you all very much and hope to see you all next week.
Great job, Scott. Thank you.
Thanks.
Have a